were unable to show how they personally would be affected in any concrete way by this regulation. They didn't say that this regulation would endanger any species in a way that would affect them. Some tried to say, oh, well, we plan to travel to a certain area where there are endangered species and where there may be projects overseas. And this failure to consult may affect those species, and then we won't be able to see them and enjoy them. But the court said no. These vague, someday intentions to visit habitats of endangered species was not actual or concrete. It was too abstract, too speculative. It didn't make out any personal injury. So, while it's true, you can have injury in fact from an interest harmed where that interest is created by statute, make sure you look real close and be sure the persons who are suing did in fact suffer some personal harm to them. So, the first requirement understanding, you need injury in fact. The second is that you have to satisfy what I mentioned is this causal nexus. Now, like any other causal nexus idea, this part of the test is necessarily somewhat imprecise. But still, to understand it and to capture its meaning, we have two requirements. First, you have to show that your injury is fairly traceable to the defendant's actions, and that if you get the relief that you're seeking, it's likely to take care of the harm that you allege. To illustrate this, or maybe to better explain it, the best way to proceed, I guess, is to give some examples. One case, a famous case in this area now, is Worth versus Selden. In Worth versus Selden, you had a whole bunch of plaintiffs, and they were all attempting to challenge the exclusionary zoning practices of the town of Penfield in New York. Now, Penfield is a suburban community, and it's right next to the city of Rochester, New York. Penfield had a situation not uncommon in some suburban communities where it had zoning for houses on large acreage. You couldn't build residential homes unless there was a minimum 2-acreage lot. The plaintiffs in that case, in trying to challenge that exclusionary zoning law, said that this zoning law effectively prevented them from being able to move into Penfield. They said they were persons of low and moderate income and of racial minority groups, and they couldn't afford to go into Penfield, and the reason why they couldn't is because there was no housing, and there was no housing because of these exclusionary zoning practices. There was only housing for very affluent, rich people. So they filed suit to challenge the exclusionary zoning law. But the initial question, and the ultimately determinative question in that case, did they have standing? The court said they had injury in fact. First of all, they said, we want to live in Penfield and we can't. Well, that's an injury in fact to them. They wanted to live there and they couldn't. They had a personal harm. But the question was whether they satisfied the causal nexus. Was their inability to live in Penfield traceable to or caused by the exclusionary zoning statute? And if they got what they wanted, if they got the exclusionary zoning law struck down, would this actually enable them to live in Penfield? The court said no. No satisfaction of the causal nexus. The court said, look, even if you get the relief that you're seeking, it's entirely unclear, and we think speculative, that you'll be able to live in Penfield. Because it's entirely unclear why there's no low and moderate income housing in Penfield. It doesn't seem like it's from the exclusionary zoning ordinance. It may very well be that it's the economics of the situation. And the economics of the situation may be the most influential factor in builders not building the kind of housing in Penfield that the plaintiffs could live in. Moreover, in terms of the causal nexus, the court said you haven't traced the zoning ordinance as the cause of your harm. It may very well be, the court said, that there's no developer who would build the housing you want. And in fact, in that case, there was no allegation that there was then any live project by any developer who would, except for the exclusionary zoning ordinance, build the housing that they wanted. So So the causal nexus was not satisfied. Now that case and its outcome should be contrasted with another case, a case that is ordinarily looked at in terms of equal protection doctrine, but it's appropriate here too. It's the Village of Arlington Heights versus Metropolitan Housing Department. In that case, you had a litigant, a minority litigant, who sought housing near his employment. And he was able to show that the zoning ordinance was actually barring a specific developer from building a low-income housing project that he could apply to live in. And since it was an actual project, and the actual impediment to the project was the zoning ordinance, he was granted standing to challenge that zoning ordinance. Now be very careful. Watch out in particular where plaintiffs are suing the government, not for something the government is doing to them directly, but rather because of some government policy that the plaintiff said is influencing what somebody else is doing. If you have those kind of facts, be alert to make sure the causal nexus is satisfied. Now, sometimes it will be satisfied. There was an interesting case the Supreme Court decided recently called Northeastern Florida Chapter of Associated General Contractors versus Jacksonville. That case involved a situation where the city of Jacksonville had a program whereby it set aside a certain number of contracts for minority businesses. And a particular business wanted to challenge that set-aside program. Actually, a number of businesses wanted to challenge it through this Northeast Florida Chapter of General Contractors. They wanted to challenge the set-aside program because they said it was preventing them from bidding on any contracts. That while they were able and ready to put in their bids, they were rendered ineligible for certain contracts because these were set aside for minority firms, and they weren't minority firms. Now, lower courts considered the question of whether they had standing and said they did not, because these lower courts said these contractors couldn't show that but for the set-aside, they would have gotten any of the contracts. But the Supreme Court said that that wasn't necessary, because the nature of their claim was not that they wanted or were entitled to certain contracts. The nature of their claim was that they should be able to bid, they should be able to compete. And since they were able to show that they were actually harmed by the loss of the ability to compete, even if they weren't able ultimately to get the contracts, that was immaterial, that itself was a sufficient harm connected to, causally related to, the government set-aside program, and the court said that they satisfied the standing requirements. Now there's one more illustration of the causal nexus rule that I want to bring up because it's a case that's pretty controversial, Allen versus Wright. In Allen versus Wright, you had some plaintiffs who were parents and also their children who were suing the IRS. And the nature of their suit against the IRS was as follows. These parents were minority parents who were attempting to send their children to integrated schools in their communities. And in fact, they lived in communities that were under desegregation orders in the public schools. But they said that they were frustrated from getting their kids to go to integrated schools, and they were harmed in their ability to have integrated schools because there were private schools in the community that were mostly white and in any event discriminated on the basis of race in whom they admitted. And although the parents didn't sue the schools directly, they instead sued the IRS. What was their theory? Well, they said that the IRS is obligated by statute, and it is, to deny tax exemptions to schools that discriminate on the basis of race. So that's what the IRS is supposed to do under the law. Now, the plaintiff said that the IRS wasn't doing a good enough job of that, and it didn't have sufficient mechanisms in place to monitor what schools were or were not discriminating. And it said some of these schools were slipping through the cracks. As a consequence, these private discriminatory schools were aided by the government because they were getting tax exemptions, even though they weren't entitled to them. And because they were aided, they were able to siphon off white students who would now go to those schools and not go to the public schools. And this frustrated, again, the parents' ability to integrate the schools in their community. So they sought standing on this basis. Well, the court said no standing. A very fractured court. It was 5-4. And and the majority opinion was written by Justice O'Connor. She said that the plaintiff's claim that students couldn't go to an integrated school was an injury in fact. That was okay. But the plaintiffs further claim that the IRS was failing in its legal duty to deny tax-exempt status to racially discriminatory schools because it didn't have a sufficient monitoring program, did not satisfy the causal nexus part of the standing test. And it didn't satisfy this part of the test